Okay, everybody, we always start on time and we finish on time, or mostly we do. And I always do a little bit of an introduction. So I'm going to do a bit of an introduction. We have two really exciting guests that are coming on today to talk to the ROI group. But part of your penance for coming on to the ROI group live, and if you watch the video recorded, is you have to listen to me for 5 or 6 or 7 minutes. I just wanted to tell you that I've had an epiphany in the last few months. This is heresy for somebody who has been in real estate for as long as I have. I have never been a Robert Rich Dad Poor Dad Kiyosaki fan. All right. And that's like, oh my gosh, I'll have 13 million people writing to me saying I'm an idiot. And between people who think I'm an idiot and Toronto Maple Leaf fans who really don't like me either, I'll be in real trouble. But I reread his stuff, and I think I owe Robert an apology. And so I'm going to talk a little bit about BRRRR strategies. You guys all know what BRRRR stands for, and a strategy that I've evolved my own, which I call the BARF strategy. But first, I'm going to talk about Robert. He published a new book, new being in the last decade. So it's not 50 years old or 40 years old. It's in the last, I think it was 2012. It's called Rich Dads Who Took My Money. And in that book, and I had to read it 3 times to make sure I understood it this time, he says why slow investors lose and fast money wins. Why do slow investors lose and fast money win? And he kept saying that in the book, and I wasn't sure I really understood it. So I think I finally cracked the code, and here's what I think he means. So what he's really saying, I think, is everybody I think on the call and people who will watch this recorded know that I'm a buy and hold guy when it comes to real estate. And people who've been coaching with me for years will know that, because I drill it into folks for, I've been doing that for a long time now. So I'm a buy and hold guy, buy and hold guy, and buy and hold guy. But when I read Robert's latest book, I realized that there's something else that he is talking about, and this is what it is. He says you should probably review your and this is my interpretation of it. You should probably review your portfolio every year or two. So if you have 4 or 5 buildings, or 40 or 50 buildings, or for that matter, hundreds of them, look at your portfolio every year. And maybe you have some properties that have appreciated quite a bit, but maybe the cash flow isn't that great. So your cap rate is, is kind of just so-so, but there's been quite a bit of appreciation in it. What I think is saying by fast money is he said, you should sell some of those. So it's a buy and hold strategy, except that, it's like if you had 10 employees and I asked you which one is not performing up to standard, you would know instantly, oh, there's Bill over there, he's not really very good. It's kind of like that. If I were to ask you if you had 10 properties, which one is not performing very well, probably an image of it or a thought of it would come to your mind in a few seconds. So I would say to you that I like that. And what he means by fast money is he means that you're selling some of your assets, taking that equity out because there's been appreciation, and you're redeploying it into assets that maybe have a higher cash flow, better cap rate, and maybe more room for appreciation. So your money is picking up speed, and I'm going to call that a trading up strategy. So that's, I think, a revision. And when I read this, and I had this epiphany, my wife and I sat down and I said, look, I think we should look through our portfolio. And sure enough, right away, there were a couple of properties that came to mind, appreciated a lot. Cash flow wasn't that great. We sold them and we bought better properties. So that's, I think, what he means by fast money beats slow money. The other thing that I think I was unfair about, and I think many other people are as well, is that they think Robert Kiyosaki is talking about no money down real estate, but I'm not 100% sure that's what he actually means. And I think his original deal back when he published Rich Dad, Poor Dad, must be 40 years ago or more, is I think he bought his very first condo in Honolulu. He's originally from Hawaii. And I think he paid $45,000 for it, and he had to put 10% down, around $4,500 plus whatever his closing costs were. And he borrowed that money from a credit card. That I remember clearly. And that really isn't a no money down strategy, because, credit card companies and banks have a nasty habit of wanting you to repay them, right? So that's really your money that you put in there. And you might say, okay, well, like he could have got an investor to put in, but then you're sharing the deal with the investors. And investors, by the way, they like getting their money back too. They're no different than a credit card company, really, or a bank. So what he really means by a no money down deal is, I think we have to take a broader view. And this is kind of an epiphany for me. I mean, it's very simple stuff, I realize. And maybe I'm dumb for not realizing it much earlier. But if you bought a condo for $45,000, you put your $4,500 down in closing costs plus closing costs, and you do a great job on leasing. You find yourself a really good tenant, paying a good rent, and maybe the value of the condo goes up in 6 months or a year. Maybe it goes to $65,000. Remember, we're talking about transactions that were done decades ago. And then you refinance it and you pull out the original cash that you put in or your investors put in. And maybe you pull out, and tax-free, of course, because it's not income, it's refinancing. You take out that money and maybe a little bit more, and then you buy another one. Buy, hold, rinse, and repeat, right? So it is a no money down transaction if you look at it over a period of a year or even 2 years or 3 years, but not necessarily on the day that you buy it. So there you go. So that's what I think is sort of maybe a somewhat new insight by me. And for those of you who know that I changed the BRRRR method to the BARF method, it's kind of a horrible way of putting it. By BARF, I mean buy and hold. So no different than what we had before. Animate, which is add new revenue streams. Rehab, renovate, rent, reappraise, refinance, rinse, and repeat, sometimes with other people's money. So I call that financing method. So that's the BARF method, but I revised it again after reading Robert's stuff. It's now called the BARFs method. You can see it down here at the bottom. So buy and hold, animate, rehab, renovate, rent, reappraise, refinance, rinse and repeat, often with other people's money, sell occasionally to improve speed of your money financing method. So it's a little bit long. I'm going to stick with the BARF. I'm not going to really change this to the BARFs method, but you understand what I'm talking about. And the missing ingredient, maybe there is a missing ingredient in Robert's work, is the animation stuff. And that's something that I have specialized in for quite some time. And that is that there are ways to add new revenue streams to almost any property, commercial, residential, even condos. We found ways to animate them and create new revenue streams. So I think that's kind of the missing ingredient. All right, enough for me. And now to our very special guest. I'm going to do the introduction, then I'll turn it over to you, Roberto, in a moment. I got to get rid of this. My apologies. We don't need that anymore. And here we are. So we have two very special guests today. The first guest is a litigator and a municipal law lawyer, Roberto Aburto. Did I say it right? Aburto?
People typically say Roberto Aburto, which is simple and easy.
Aburto.
Aburto is the Spanish pronunciation, but Roberto Aburto is the normal.
Right. And you know how I did that, Roberto? I'm going to clue you in a second. My wife speaks Spanish. So I asked her, and she said, Aburto. All right, so I did my best. So we're very, very fortunate to have Roberto here. And after Roberto finishes, we've got Ben Canning here, a really cool young fellow who does these unbelievable geodesic domes, which you can grow almost anything in, all the way from the equator to the Arctic. And if you could grow veggies in the Arctic with these things, you can grow them in the backyard of your investment property, your industrial property, your commercial property, your restaurant, whatever. And I've always had a dream of being able to hold a meeting in a greenhouse, or have my workspace there. And I think you could do that too, maybe even live in the darn thing. So we're going to hear from Ben in the second part. But anyway, so we have a partner. He's a partner. That's a big thing at Gowling's, which is a huge firm, municipal law and civil litigator, as I mentioned. And you can read for yourself here. I hope you never have to call Roberto, except that the truth of the matter is that municipal law has become so complicated and so full of landmines that I think Roberto will be on my speed dial from here on in. So Roberto, with that introduction, over to you.
Yeah, thanks, Bruce, and a pleasure to see everybody sort of virtually today. Yeah, no, my area is municipal law. Um, so that's really, it's a pretty broad scope. We have one of the largest municipal groups in Eastern Ontario. There's 7 lawyers in the Ottawa office, so me and one other partner, and we've got 5 associates. And so, I mean, ideally, you don't want to have to talk to me for extended lengths of time and extended periods of time, because litigation is a complicated and expensive process. Uh, where there can be a lot of value is the consultation pieces and the strategic piece, which I hope is one of my strengths, and I think is one of my strengths. So when people have issues, when people have issues, I really encourage folks to don't hesitate to send an email or pick up the phone, and happy to have a call, and that doesn't need to get the docket running. Happy to sort of say, okay, where are we? Where are the issues? And then where do we go from there? So that's a big piece of what we do. Sort of my bread and butter is anything relating to real estate development. We call ourselves sort of anything relating to dirt. And so the land use planning piece, the Planning Act, Heritage Act, development charges, that's a big chunk of it. Expropriation is also a large part of the practice. I sit on the board of the Ontario Expropriation Association, which is a thing that exists. Most people probably have never heard of it, but we also involved in municipal property tax assessment, and not a lot of lawyers in the province that do that, and certainly active in the Canadian Property Tax Association in that regard as well. But then also just the litigation that flows from these things, and having knowledge of all of the development processes gives me a unique perspective when litigating different matters. So have a bunch of matters with the pandemic and the short supply of land, lots of cases right now with aborted sales or sales where people will refuse to close on the agreement to purchase and sale, and a lot of those things have had Planning Act approvals as conditions. And so really understanding the process and what's gone on there puts us in a good position to pull that apart and come up with the best strategy in terms of how to go forward. Go to the next slide.
Just before I do, Roberto, just an apology to everybody on the call. There's a setting in Zoom to mute everybody as they enter, and I forgot to do that. So if you're not muted, can you, just in case somebody comes in or the dog starts barking?
So, and we can go to the next slide as well. And so I'm going to talk to you about 2 cases today, two of my cases. These are really the best case scenarios. I didn't pick cases that I lost. We certainly win a lot more than we lose. But these cases are really the best case scenario. From a high perspective, litigation, it costs. It costs time, it costs money, and a lot of times where folks spend time litigating, they're also not spending time on their core business as well. So there are opportunity costs there as well. But that being said, these were a couple, I thought, interesting cases in the real property sort of development context that folks might find interesting. So next slide. The first one is the Millerson Group Inc. v. Huntington Properties. So I represented Millerson Group as well as Dharma Developments and a couple of individuals. Going to the next slide. So there was 2 groups of investors involved in a residential and commercial development, so mixed use. And the development did not proceed as quickly as one would have hoped. So sort of the years go by, the soft costs escalate, the hard costs escalate, and it gets hard to carry on. So going to the next slide, there was a dispute between the parties, and they entered into a settlement agreement. So there was no formal litigation at that time, but both parties got the lawyers together, came up with an agreement wherein there would be a buyout of Millerson by terms from pursuant to a promissory note, and then Millerson got a release in return. One payment was made pursuant to the promissory note, and then there was a default on the second payment. Next slide. Millerson sued for summary judgment on the note, and what summary judgment means is it is a summary disposition tool in the courts. So rather than going to a full trial, you can say, oh, this is simple enough that I think I can win on a summary judgment, Millerson sued on a summary judgment. At that point, there was a promissory note and payment had not been made. So it takes months to get a motion date, and you put your materials in. I think it was less than 2 weeks, probably closer to 1 week before that Huntington raised claims of misrepresentation, saying that there was fraudulent and negligent misrepresentation, which really go to complicated issues of fact. And so, again, if you're going to summary judgment on what does the contract say and did they make payments, that's a lot simpler. If the court has to weigh the evidence of who said what and when and who was credible, that's tougher. And so that was raised at the last instant, and the motion for summary judgment was unsuccessful. But notably, no costs were awarded to Huntington because it was raised at the last minute. So a couple of years file ahead, and I actually came onto this file after the summary judgment motion and only in advance of trial. The next slide just sets out the legal test around misrepresentations. I'm not going to go deep into the legal weeds. I don't, if people want to philosophize about Queen and Cognos, we can do that as well in the questions, but we can just move on. So we had a 2-week trial, and in the 2-week trial, I think there was about 7 or 8 witnesses. I cross-examined the primary witness from Huntington for 3 days. So that is a long time of getting pressed on. And a very smart individual for sure. I have a lot of respect for him, and he's been, Huntington is obviously a very successful company. When you're into litigation, it is a tough game, and I don't think it's an unpleasant experience, I think, to be cross-examined for 3 days. And really, I mean, it was going through, there was meeting minutes almost monthly relating to this project. And so there were some bald statements saying, this never happened and that never happened. And so we went through, meeting minutes over a multiple year period. So anyway, it's a long and arduous process for sure.
Roberto,
yes.
I was examined by the Perry Mason of OMB, Ontario Municipal Board hearings, Tom Lederer, back in the 90s on the Palladium hearing, 3.5 days. And what Roberto is saying is not just right, it's 100% right. I'm not sure what the situation is in the United States, but in Canada, and I think we follow the British tradition, when you're going through cross-examination, when I was going through cross-examination on the Palladium, now the Canadian Tire Center, whether it could go ahead or not, you're not allowed to say, hold on a second, can I talk to my lawyer? You're out there on an island by yourself, so it can be very stressful. And even in the breaks, you're not supposed to, go to your lawyer, what should I say? So you have to figure it out on your own. Isn't that right, Roberto?
Yeah, no, absolutely. I had a tribunal hearing in Grimsby where after we went overnight one day, and the person got up for cross-examination, and he said, well, I spoke with my secretary last night and I have all this new information. And you could just see the lawyer go white on their side, and the members tore a strip off of them for sure. So no, you're in the cone of silence, and it is a lonely place to be. We focused in at the trial about misrepresentations. There was 3 potential misrepresentations that were alleged. One, that the project would break even. And these were on reports that were filed consistently for the purpose of financing that had financial projections in them. I think where we made some headway in front of the judge was that we showed that the reports had been signed by some of my clients, and then after the settlement agreement, similar, if not identical, reports were signed by Huntington. So if it was a misrepresentation, it was one that was carried on. And so the court concluded it wasn't a misrepresentation. It was just projections of a budget, which is different and distinct. Next slide. There was also a dispute as to whether the development charges had already been paid. There was actually an entry in the accounting that said it was on hold. So it was not, that wasn't the strongest of claim, and we were well to get rid of that one. And on the next slide, there was a question as to whether some agreements of purchase and sale, again in the context of the financing, were valid. and the court determined that the sales remained in place and did not close because Huntington was not in a position to deliver the units. So, it's interesting that we're sort of distilling these three representations down from a 2-week trial, from days and days of evidence and thousands of pages of documents. And that's what it really comes down to. It's trying to create a narrative, a trial, which is what we do, or try to do. So in conclusion as well, the court also considered, on the next slide, the release that had been signed and whether or not to enforce the release. There's a strong body of case law around enforcing releases. Remember that before the promissory note was entered into, both parties retained lawyers and negotiated the terms of this minutes of settlement and this release. Like at trial, we were putting in emails between the lawyers, putting in different versions and showing that the other side had made changes. So trying to suggest, oh, we didn't understand, or it wasn't, really intentional, when your lawyer is changing the words of it, it was very strong and compelling, and certainly nice to vindicate our solicitors who don't always get direct feedback from the court on the enforceability of all their agreements, but it was fully enforceable in this case. Going to the next slide. So I've talked about costs, and again, costs in the context of litigation doesn't include your opportunity costs and your time and stress and all of those things. But in Ontario courts, costs generally follow the successful party. Costs are typically awarded on a partial indemnity basis, so that's usually 40 to 60% of reasonable legal fees. And in some circumstances, you can get to substantial indemnity. This is a separate and distinct from, I talked about how I do expropriation. That's an interesting nuance in that the principle of full indemnity applies. Typically, the starting point is full indemnity of costs in expropriation. There can be reductions for reasonableness again, but that's a different cost regime. In the courts, this is the normal process. I'm going to the next slide. In extremely rare circumstances, one can get full indemnity, or they call it solicitor and client costs. So again, that means that Gowling's has invoiced it. This would be 100% of Gowling's invoice if it's full indemnity coming back. And so really, really rare. But in cases where there are allegations of fraud that were falsely made, that opens the door on full indemnity. And that was this case, did include that.
Yep.
Going to the next slide. So we sought full indemnity and substantial indemnity. And then going in the next slide, we sort of hit a bunch of the factors that can often get you to substantial costs. And the fact, I think, that there was multiple of these was what helped get us to full indemnity. First was the unsuccessful allegations of fraud. I think not all lawyers take that fully into account. When you're doing your pleading or you're framing your case, if you put fraud in play, you're also upping your risk and the ante on the case in terms of your potential liability of costs if you can't prove fraud. Second was that the note provided expressly the solicitor-client basis cost, meaning full indemnity.
Wow.
Third, there was our judgment exceeded offers to settle that had been made. So Huntington could have paid less in advance of the trial. And how that works with those offers under Rule 49 of the Rules of Civil Procedure, there's a bunch of mechanisms and boxes you have to tick. And one of them includes keeping the offer open until the start of the trial. But if you beat that at trial, then you can get escalated costs. And then number 4 on this was the late response to the motion for summary judgment that stretched out this litigation a few more years. So we were able to tick all those boxes, and we did get full indemnity costs.
Wow.
A couple minor reductions, but really a very unusual result. But that's where part of the strategy that you set up in the litigation, including offers to settle, including prospects of what does the fraud mean, those things can help position you so that you can try and get escalated costs. The other thing about the strategy around trying to position yourself for escalated costs is it tends to change the risk profile for the other side.
Right.
And that can help bring them to the table sometimes on a settlement by changing their risk profile. So Rule 49 offers to settle, I make them all the time. And I mean, what happens there is, they can always accept it. So it needs to be something you can live with, but there's a lot of cases where you think, well, they'll never take it. So you might as well put it in there and at least give yourself a better shot. So going to the next slide. So this is a numbered company against Kingston.
Hold on a second, Roberto.
Sure.
I want to can I add just a quick couple of comments?
Yeah.
So for those of us on the call and like the ones who will watch it later on recording, Roberto is obviously a polished presenter. He's full of energy. He's very knowledgeable and he's very personable. And you might ask yourself the question, should I have, excuse the language, should I have an ass kicker of an attorney, or should I have somebody who's obviously as thoughtful, but also kind and authoritative, but still quiet in a way, litigator? And Roberto's in the latter category. And I think there's a lot to be said about somebody who's thorough, knowledgeable, but also quiet and authoritative, as opposed to being who was the lawyer who represented O.J. Simpson? He's passed away now. Johnny Cochran. Yeah, Johnny Cochran was very theatrical in that, but certainly in places like Canada and Britain, Australia as well, New Zealand, maybe less so in the United States. Having somebody like Roberto on your team is really good, and it plays very well. Now, I have to tell you, it doesn't necessarily play as well in the media. So if the media are taking a big interest in it, they're looking for, excuse my language again, the ass kicker lawyer, and they score it as if they're scoring a hockey game or a soccer match or a football game. But the judges in Canada and elsewhere don't tend to be necessarily persuaded by the same theatrics. And one other thing I would say to you is that if you are in any kind of a litigation dispute, you do need a good attorney, right? But you need to also contribute. And I'm going to tell you a little story about my 3.5 days on the stand defending the Palladium, the Canadian Tire Centre. We had a government in Toronto, the NDP government, who didn't want us to build the arena where it is. They wanted the NHL expansion franchise not to go to Ottawa and the Senators, but to go to Hamilton, where they had greater political strength. So they had tremendous resources. I mean, the provincial government has more money than I do, by quite a margin, I might add. And so I spent, as I said, 3.5 days on the stand. And towards the end of my cross-examination, I think the second or the third day, and I think it might have been the second day, I set a trap for the attorney. Usually the attorneys, the prosecuting attorney or the defense attorney or the litigation attorney sets a trap for you, but I set a trap for him. And at one point, I turned to the 3 panel members, there were 3 judges, and I said to the chair, I said, "Chair, may I make an offer publicly?" And Roberto was talking about settlement offers, and that's what triggered my memory. So I said to Mr. Lederer, who was representing the province, I said to Tom, I'd like to make an offer to settle this matter right here, right now, publicly in front of, there was dozens of media types and hundreds of people paying attention, maybe even tens of thousands of people. And I made an offer. I said, if the board sees fit to give us permission to go ahead and build our building, the Palladium, the 20,000 seat arena, on 100 acres. The other lands that I own there, 500 acres, I will freeze development on that for a generation, for 25 years. The province has said this is not about hockey, it's about real estate. I'm going to prove that's not a sound supposition. I said, what I'm going to do is I'm making the offer to the government of Ontario, to Mr. Ray, who is premier of the province, and to you, Mr. Lederer. I will freeze the other 500 acres and I will do my best for 25 years to keep it in agricultural production if you give me the 100 acres I need to build the Palladium, Canadian Tire Centre. That way, the NDP government wins, the union jobs that will be created by building this building, the unions win, and hockey fans win. And the only loser will be me, because I'll have 500 acres that I can't use for at least a generation. Now, that was a trap. And the reason I put that trap in is at noon that day, my lawyer, who was just like Roberto, a real true gentleman, said, Bruce, The panel, which means the judges, have gone cold. We're losing. So I said to him, don't worry, I'll fix it. Now, Roberto, when a client says to you, don't worry, I'll fix it, you start to worry, right?
Yeah.
And sure enough, he said, well, what do you have in mind? I said, I'm not going to tell you or anyone else. I'm going to fix it. So by making that offer, the judges said, well, Mr. Letter, what do you want? Well, Mr. Letter said, look, we need to take a timeout. I need to go and consult with my client, the premier. So he had to fly from Ottawa to Toronto to consult. That night, one of the secretaries to the cabinet, who was a friend of mine, told me that he met with Mr. Ray and his inner cabinet. At that meeting, Tom said, look, Firestone is desperate. He's losing. He wouldn't have made that offer to freeze 500 acres of his land, to sterilize it for a generation if he was winning. He's losing. We're going to win. And he said 3 words that lawyers never say: I guarantee it. So he said to the premier of the province of Ontario, I guarantee it. The premier says, look, our lawyer's guaranteeing that we're winning. We'll go through to the end. The total hearing was 13 and a half weeks, and we spent $3.5 million on legal fees for that one, Roberto. And so the next day he came back, Mr. Letter did, said, no, the trial continues. And Mr. Firestone continues to be cross-examined. His offer is rejected. At that moment, I knew we had won the hearing, because the panel member said, wait a second. This was a win-win-win for Mr. Ray and his government. And there must be something else going on here. And Mr. Firestone's supposition that this is a political matter and nothing to do with land use is right. I knew that the provincial government had lost. And sure enough, 13 and a half weeks of hearing, 2 months later, we got the decision and we won. So Roberto, what do you think?
Yeah, no, well, you would terrify me as well, I think. Certainly, when the clients go rogue, I'm glad it worked out on that circumstance, because
well, you just damned me with faint praise, you know. So I need somebody to come over to my house here and pull the knife out of my back that Roberto just put in. All right, let's go on to the next one.
Well, the other point that I wanted to sort of make too is, you sort of talk about an ass kicker, and I would say that I am as aggressive as I need to be. We push a lot of files very hard, very quickly. But it's got to be the right time and the right strategy. But when we've got it, you know, and I think that's where one of the challenges clients have sometimes is we sort of distill it down to some options, and it's, you know, either we can play it out through this normal slow process, we can push it in number B, or we can just sit on it. And it's like, you know, trying to make a choice sometimes is challenging, because I'm saying, like, well, if it's B and we're going to push it, give us the go ahead and then away we go. And it's true that that's, you know, quick means lots of lawyer time, means more expensive, but it also means it's going to get done sooner. You know, sooner can be relative. Sooner may be 5 years to get to trial instead of 8 years, which may not be that palatable. But it's certainly we do aggressive tactics, and that's actually pretty evident in this case here, this next one. So it's a numbered company against the city of Kingston. You can go to the next page. I represented J. Patry Enterprises, who's one of the larger developers in Kingston in terms of multi-res. And so, sorry, Bruce, you said you have some familiarity with Mr. Patry?
Well, you know, in both cases, I think I know all the parties. I did a little work, you know, full disclosure, for Jay on one of his 1,500 unit subdivisions in Kingston. And I know the two principals that you're talking about on the previous case. So my fingerprints indirectly are all over this. Yeah.
So this was a zoning amendment for 501 Frontenac Street in Kingston. A law firm put in a letter of objection. A company was incorporated just before the appeal period. And then this numbered company filed an appeal. This was in 2019, and there was urgency to get this thing done. We brought a motion to dismiss against the appeal, as opposed to having a full hearing. And we talked about summary judgment and how it's a high bar and there's not a lot of success for that in the Superior Court. Actually, motions to dismiss at the Ontario Land Tribunal have a reasonable prospect of success. There's a lot of not super well articulated appeals that are filed sometimes, often community members. But this case was a different matter. So the appeals filed, we bring a motion to dismiss. We actually had it heard, I think it was weeks before the pandemic, before that Thursday night where all the NBA games got canceled. So we brought this motion to dismiss, and City of Kingston took no position on the motion. It's interesting that when you allege frivolous appeals, sometimes actually the City of Ottawa will, if they agree, will support these motions, and that does happen on occasion, so sort of supporting their own bylaw, but Kingston's typically not as active on those. So going to the next slide. And so it wasn't a major zoning amendment. It's increasing the number of units from 71 to 99, reducing the bedrooms. So it's changing the layouts of the interior, all related to the density and the parking. Like the exterior, there was no changes to the exterior of the building. And the building there was construction ongoing, like it was midway through. So the interior design hadn't been all set up, but it was under construction. And so there's an appeal that was put together. Going to the next slide. It was a bunch of grounds put together by a land use planner at a law firm. So most land use planners that we work with often work at consulting firms like Novatech and Poten, are obviously two of the big names in Ottawa, lots of smaller shops as well. Law firms will have some in-house planners, so we have a couple in-house planners as well. Basically a planner at a law firm went through. One of the things about planners from law firms, they can add a lot of value, especially on transactional pieces or doing some of the applications. But if you go to the tribunal, they're not going to be an independent witness. But regardless, they had sort of pulled some arguments together. We brought our motion. In our motion to dismiss, we had an affidavit from a planner. And as well, we had another affidavit that went through, and you go to the next slide as well, that went through pulling apart the history and some of the law firm detective work about this one. There's another developer, Podium Developments, that was developing across the street from this. And their fingerprints were all over this. So they'd incorporated a company. So the company, on the corporate profile report, it shows who the directors were. And there was one director listed. And he, when you Googled him up and looked on his LinkedIn, was worked at Secure Capital, which was connected to Podium Developments. And we were able to pull that together through different website pieces. And very easily able to establish the Podium and Patry were developers and competitors in the market. And part of the argument on the motion was that the other side was arguing, well, there's not enough evidence to tie these two together. And the tribunal disagreed. Mr. Lonte agreed with us that there was a connection. And once he made that connection, like some of the density and issues were things that they were doing with their own development across the street. So the credibility flew away. The next slide is just the legal test around that. And again, the motions to dismiss, they have a higher level of success, especially right now for quick hearings. The tribunal will not have case management conferences. So like there's a ton of minor variance hearings in Ottawa because the Committee of Adjustment turns down a lot of stuff, especially panels 1 and 2. And so often those will go straight to just a one-day hearing. But if you're going to get like a 3-day hearing and you're going to have a case management conference, you can often bring your motion to dismiss and have it returnable at that first case management conference. And then, because especially with these Planning Act ones, I mean, really time is money. The longer it takes, it's delaying the project, there's carrying costs, and you can't go forward without your approvals. There's only so much you can do. So it's a handy tool that's useful in some but not all occasions. The risk is that, you argue it, and then if you're unsuccessful, you still got to do the hearing, or you argue it, and then it's reserved. And it's been much better at the tribunal, but there have been circumstances where it takes a long time to get a decision. I've had a 1-day minor variance where it took me 13 months after we argued it to get a decision. I think the tribunal's record right now has been better in my experience. There still are those outlier cases, but you're all trying to know, how do you get from your start to your finish as quickly as possible. And this, we got this in And then, all the hearings were canceled and the tribunal members all got to sit at home and write all their decisions. So we got a decision actually relatively quickly on this one, which was good. And so I've just included some of the legislation there. We could go to slide 26. And yeah, I can go a couple more ahead to 26. And so, as I said, we put in a planner's affidavit that sort of spoke to the merits of any of the issues that had been raised. The other side didn't put in a planner's affidavit, and to defeat a motion to dismiss, a planning affidavit is not necessary. There's a couple cases where you have it, but there's a couple cases where people got away with not having a planner, and dozens and dozens and dozens where they didn't have a planner and they were unsuccessful. So having a planner in response to those and that's not determinative. Like we did one over in the Glebe where there was a motion to dismiss and they did have a planner's affidavit, but it still didn't raise any authentic planning issues. And we were able to establish that, and that one went to the divisional court, and we were successful at the divisional court as well. So we are successful. So we go to the next slide. There was no legitimate planning ground in the appeal. And going to the next slide, they sort of want, we've got to go through the merits of it. I don't purport to maybe go through all the planning specifics. So we can go through to slide 31. This is where we get to another unusual finding where there's a conclusion of bad faith. And bad faith is those are the key words right. that are rare to establish. It's a very high bar to show bad faith. But our detective work got us there, I think, coupled with the fact that, the starting point is the developer across the street appealed it and hid their identity. So, that informed it to a large part. But so the appeal was dismissed. Going to the next slide. So on Planning Act cases at the tribunal, costs are extremely rare. As I said, that bad faith word was the key point there. And so normally costs are not awarded. And if they are awarded, they are awarded on a small scale. So I had a minor variance in Ottawa where between the planner and my fees, I think we were around 18K or something like that. And we sought a cost, and we got costs because the neighbor was a land use planner and put in an appeal without authentic reasons. And we got costs of $3,000. And that's a good result of costs in the tribunal. It sort of gives you a sense of the scale of what normally happens. But here with the bad faith, we saw an opportunity to go for costs, and we went for it. Going to the next slide. So it talks about, the conduct, and basically the rule sets out the bar around costs, and that continues on the next page. What's not in this rule, and what we did, going to slide 35, was we saw costs not only against the numbered company, but against the individual in his personal capacity.
Cool. That's cool.
And it's not in the rules, but there is case law, not case law at the tribunal until we did our decision. Wow. But case law, so we had to deal with, one, the tribunal's jurisdiction, and then two, that we're meeting that case. But we put it in, and costs are all in writing. So we did a submission, they did a response, we did a reply. We sought full indemnity or substantial indemnity or partial indemnity. One of the points that we made was the appellant corporation has no assets. So if they incorporate a judgment-proof corporation and they get away with a cause award, that defeats the whole purpose. And going to the next slide, it was the first time the tribunals made an order as to joint and several liability against a director in their personal capacity. They found it was clearly unreasonable, vexatious, and bad faith, and went with partial indemnity costs, which again is higher than the typical costs associated at the tribunal. But even in this case where we got personal liability, we didn't get full indemnity for the Planning Act case. So on the next slide is just some of how we got there. On the jurisdiction piece, we had to go to the Statutory Powers Procedures Act, which is a statute that generally applies to the tribunal. And the man of straw test. Did the non-party have status to commence the proceedings? Is the non-party the true litigant? was the straw man put forward to protect the non-party from liability for costs. And so that's the test we had to meet and that we were able to meet.
Wow.
So a very unusual outcome, but and an aggressive position to take in respect of costs, but it worked. So as I said, very much an outlier. If you're going to the Ontario Land Tribunal, don't expect your costs back unless it's an expropriation matter. So that's kind of it. If anybody had any questions.
Well, I have to say, Roberto, that is a really impressive. I mean, I can tell you, I was very familiar with the first litigation that was ongoing, and I personally thought your chances of winning that on behalf of the client that you and I both know was pretty low. And when he told me that they had won, I went, "Who was that?" And that's the first time I ever heard your name. And I'd like to make a few points, and then if there are any questions, you guys know where the chat box is. Please pump in a few questions. And Ben, we're coming to you in a couple of minutes, so don't go away, Mr. Canning. There's a couple of things that I'd like to highlight for people. First of all, I'd like to talk about the notion of competition. I have a different approach to competition than that individual, that corporation, that straw man in Kingston has. I like competition. My experience is when I was a developer with Terrace Investments Limited, if I was building an office building here and one of my competitors, say Canderel from Montreal, came and built an office building right across the street from me, I would jump for joy. Some of my staff would come running into my office. Oh my God, you know, Canderel's building right next door. They just announced it. I go, that's great news. And people would look at me like I'd lost my mind. But the reason why I like competition is this, that if Canderel comes to the neighborhood, they'll do a heck of a lot of marketing. And people who come and check out their new building probably will walk across the street and check out our building. And so you often find that competition actually leads to a bigger market. And certainly in a small market like Ottawa, having a big developer come in and put a setup right next to you does generate more traffic to the area, more interest in the area. And we found our leasing got better, not worse. So I would caution you about being too afraid of competition. The other point I think I would draw from Roberto's presentation is something that I call, and I think it's an old term in legal matters, clean hands. Don't do anything. Don't write in an email and don't come up with any cockamamie plans that you will end up regretting if it ever comes to light in a court setting. Don't send out any emails that you would not want on the front page of your local newspaper, right? There's a National Football League head coach who just lost his job because he wrote very, very, very awful emails. But how stupid is that, right? Their email is not private. But private or not, don't think that two wrongs make a right. They don't. And in the court of law, they certainly will they will completely undermine you, even if you think you're very clever. All right, so be careful with that. So I have there was one more point, and then I have a question for you, Roberto. Something that's very interesting here is Roberto was able to pierce the corporate veil and go after that director. So for those of you who think that having a corporation protects you from all liability, that points out it does not. If you're a director or even possibly a shareholder, right? You can be held responsible and you can pierce the corporate veil. For example, if you own a property and there's a environmental spill on that property, you as a director of the corporation could be held personally liable. When I was with the senators, one of the questions I would ask at every single board of directors meeting is, are we up to date on our HST, back in those days, GST filings? Because again, if you don't pay your income source deductions or your GST or now HST in Ontario to the government of Canada, you could be held personally liable. So don't think that a corporation protects you from everything. Now to the question, Roberto. A client of mine had a small building in Little Italy in Ottawa. And it had a two-bedroom apartment at the ground floor. And he wanted to put up one wall, put in an extra bathroom and a small kitchen and create two one-bedroom apartments instead of one big two-bedroom apartment. It's consistent with the City of Ottawa's plan for intensification, affordable housing, et cetera, et cetera, et cetera. He did a pre-consultation with the city, and the young planners said, here are all the studies you have to do in order to get, to submit for a building permit. And those studies were going to cost about $45,000, maybe a little bit more, to do a $15,000 renovation. And one of the studies was a streetscape heritage overlay. I had never heard of such a study, and I know most of the studies. And I said to the young woman, I said, I've never heard of that one. Streetscape heritage overlay. What the heck is that? Well, your client is going to have to show that the changes he's making will not affect the heritage, the streetscape. And he'll have to hire an architect who specializes in heritage at some significant cost to assure. And I said, excuse me, I don't think you've been listening. And she said, what do you mean? I said, the building already has two doors, one to the front, one to the side. He's not changing anything. Oh, but he still has to do that study. I said, well, that's ridiculous. That doesn't make any sense. So he walked out of the meeting, which I supported. And of course, guess what he did, Roberto? Maybe he did that renovation without a building permit, which is not a good outcome. So the question I have for you is, if you get some unreasonable requests such as that, can you actually go to the tribunal and appeal that?
Well, yeah, we get a lot of unreasonable requests, and that is we are very gainfully employed because of that. I would suspect that on this one, this might be a situation where, did the city say site plan applies, and so you have to go through the site plan process because they do that more broadly than they are entitled to from a legal authority perspective. So site plan is only triggered if there is development, and development is defined in the Planning Act. If you are changing the interior design or layout, that does not trigger development. And so you cannot use site plan to require studies and various conditions. They use a lot of different things that they often don't have authority to do. So it's in a case by case basis. It sort of depends. And for some of those cases, we'll, write a letter or push it up the chain to try and sort of make sure that we're kind of getting to what's within the authority of the city and what they can do. Or if it is a site plan and there's conditions that are outside their authority, you can't appeal that to the tribunal, but it's going to be expensive and time consuming as well.
I understand that, but I think what Roberto just said is very, very important. And one of the reasons why, I worked with lawyers, attorneys like Roberto and others, Steve Shepard, of course, and many others, is that I have found that people like Roberto and Steve Shepard and others are able to talk to the city from a legal point of view, and often will get a better hearing than maybe you or I will get. Planners are tired of hearing from us, and I guess the planning department, but when they hear it from a lawyer, sometimes there's a level of respect there. And so sometimes, and I think Michael put that in the chat box, sometimes just a warning letter from an influential and authoritative lawyer like Roberto can get you where you want to go without a lot of expense and time. All right, so Ben, are you there? Ben, do you mind unmuting yourself? And can everybody follow my lead and put go to the reactions and give Roberto a few of these thumbs up, clap, 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 because it was a fantastic presentation. Oh, there we go. We got Chris doing it, Ben's doing it, Rick, Skylar. How about you? Skylar is your client there. And he's not giving you the thumbs up. That's not good. Come on, Skylar, give Roberto a thumbs up or a clap, clap. Thanks, Janice. No, really, Roberto, I don't know what to say except thank you.
No, thanks, everybody. Don't hesitate to reach out, even if you're not sure if you've got an issue that I can help with. Happy to help.
All right, Roberto, if you have time, hang around. But if you don't, we understand. At $1 million an hour, you've got other things to do.
Okay, thanks. Have a good day, everybody.
All right. So where's my friend? Hi, Ben. How are you?
Yeah, great. How are yourself, Bruce?
Oh, good, good. Sorry about being about 10 minutes late, but I'm really excited to hear about Arctic Acres. What a great name! It's ArcticeAcres.ca. And just before, about an hour and a half or 2 hours ago, Ben sent me a video. Ben, just for the heck of it, would you mind if I showed the first 3 minutes of it?
No, I was going to ask. That would be fantastic, actually. It
All right,
helps put
because
the
there's
image in
this,
everyone's
there's this
mind.
fantastic video on what Ben is doing. It's groundbreaking, and I want to say, is it your uncle? Is Chris Canning there? There's Chris. Is Chris your uncle?
Chris is my cousin, actually.
A cousin. All right. Well, there you go. So, Chris, I want to thank you for suggesting having Ben come and spend some time with us. So I'm going to go over to you. Oops, I'm going to undo that. Sorry about this. I just learned, my wife taught me this. When you're sharing a screen, Zoom allows you to share sound and optimize for video clips. So when you hit the share button, there's two little buttons at the bottom. It says share sound and optimize for a video clip. So I've done that, and I'm going to make this full screen. Ben, can you see this okay?
Yep, absolutely.
All right, so I'm going to play the first 3 minutes of it, you guys. It is a tremendous video. Here you go.
Brush your teeth in less than 10 seconds with this revolutionary toothbrush.
Sorry,
It was created by a
that's an ad.
There are a few things that human beings need to survive, really, home, water, and food. And so the ability to grow your own food is just so freeing. Growing Dome is a 4-season, year-round greenhouse that allows most folks to be able to grow pretty much anything they want in their backyard. The idea is self-reliance and sustainability. So they're geodesic domes. That's important for a number of reasons, primarily being strength and longevity. So the domes themselves can withstand up to 7 feet of snow on top of them. They'll withstand about 180 km/h wind speeds. They're bolted into the ground. They don't move anywhere. And the idea is that in some of the harshest climates that you can still rely on yourself to grow all your own food. So one of the best things about the greenhouse is that it's off-grid. So the greenhouses rely on solar passive heating. We have a thermal mass of water in the back of the greenhouse in the north wall. On top of that, there's the solar ventilation, and what that does is it allows for anybody, anywhere, to basically put one up in their backyard and not require electrical service. It uses the sun to heat itself, cool itself, and run all of its internal functions. So basically we have the foundation, which can be concrete or gravel, really depends on what the environment calls for. And then it's constructed out of the strut material, which is a lumber. We prefer to use some beautiful Western red cedar, especially in the greenhouse. It lasts in the humidity. We build our own custom hub system, which connects all of the struts and helps build our dome structure. And then we sheath the entire thing in a polycarbonate material, which is a multi-wall, but a 1/2 inch thick plastic material, which is translucent, lets the sun in, but keeps all the snow, the wind, and the pests out. The greenhouse panels, the polycarbonate panels, they're really important for a lot of things. They have a high R value for their structure, at 1.6, which doesn't sound like a lot, but for a greenhouse, that's huge. They also have a really low U value, which means that they don't hold cold. So even in the middle of the winter, you can touch them and they still feel warm to the touch. That really helps with the plant life on the inside. On top of that, they're hail resistant. Unlike glass, you can't throw a rock through it. The other amazing thing about these guys, the polycarbonate panels, is that they're 100% recyclable. So any scrap that we have from our production, or if any client needs these replaced, we cut them down into strips, and we actually have a polymer recycler that we work well with. They take them, they chip them, they melt them back down into feed pellets, and a brand new sheet can be made out of an old sheet. This is one of the solar fans that we have basically controlling the internal temperature of the greenhouse. This solar panel can be tilted up or down to catch more or less sunlight, and it's directly mounted to this intake fan underneath. They have thermostats and they have shut-off remotes and timers. The idea is you don't need to bring in electrical service. You don't need to bring in hydro lines and trench them. You can if you want to, but this option allows anyone to put one up anywhere in the world and survive off-grid.
Well, how about that? Ben, did it sound okay?
Yep, no, the audio was great, actually. It was a good choice to switch it over.
Oh, good. I'm glad. So, Ben, I have your presentation here, and I'll do the same thing for you that I did not that well, mind you, for Roberto. So I'll share it in a moment here. And once again, Ben, thank you so much for joining us today. All right, so I'm going to share my screen again, and there are your slides.
Wonderful. Thanks very much. It's a pleasure to be here. Pleasure to meet everyone digitally and to chat about something we've been working on for a really, really long time. So As you've seen, the growing spaces, the growing domes that we create, 100% Canadian made. We manufacture in just outside of Ottawa, Ontario, actually. So as of last quarter, we are in every province and territory, which is exciting. And we're 2 years old, and we're just thrilled to be able to tell you a little bit about ourselves. So if we could click into the next slide. I'll just preface this with saying this is our basic pitch deck. The video that you watched was a video done by Exploring Alternatives. We have a number of other videos with some large YouTube channels that really walk through the product. Today, I'll talk a little bit about our company. So really what we looked at was, we're living in the 21st century, and, we still don't have the ability to, to be able to be self-reliant and to be sustainable and to look at our own backyards, not as just, a patch of grass, but what else can we be doing back there? And so, we dove into that problem head first, probably about 8 years ago in a completely different company. And what's boiled down today is still true, meaning that there isn't a lot of solutions for folks to be able to rely on themselves. So what we build, geodesic domes is the fancy name for that structure in the background. It's a pattern dome that we prefabricate into a kit form. So when anyone orders, it comes with a full digital walkthrough web series for how to install it, how to maintain it and care for it. And we offer it in 6 sizes, starting at 165 square feet up to 1,375 square feet. All of our products come with multiple foundation options, as well as stamped plans for permits. And we've often lent a hand to be able to make sure those permits go through. We haven't had a single client. We have over 100 plus to date that haven't had a problem with getting their permit in order for their build. The last thing is the durability. So as the video kind of mentioned, these structures are quite strong. Set up to 7 feet of snow, 180 km/h wind speeds. Way back when, in my first kind of go at this, we started a charity and we built them up in the Arctic. We built them as food production facilities in the Arctic Circle, and we kind of said to ourselves, if we can make them work up there, I think that they're going to work just fine in the rest of Canada. And that was true. So if we can skip over to the next slide. Again, a little bit more information about it. So the greenhouses themselves, when we say they're rated for 25 years, typically that just means that they need a bit of a refresh. So the polycarbonate paneling on the outside can be changed, the weatherproof ceiling membrane can be changed, and we can assess any sort of wear and tear down the road. Now, we have had some greenhouses, standing because we partnered with an American company to bring this product to Canada. We've seen some of their older greenhouses standing for 30 plus years, which is really exciting to see, knowing that, we're just kind of getting into this. And as mentioned, everything manufactured in Canada. We source our lumber from the West Coast, all of our doors from local Canadian manufacturers in Ontario and Quebec, and we manufacture in Ontario as well. And that's something really important that we're going to keep doing. We can keep going. So as I kind of alluded to previously, we have an American partner company that we work with. Their name is Growing Spaces. They handle the American market. So if you are watching or tuning in to this video south of the border, as we say, skip on over to their website. We offer and manufacture the same kit almost identically. So feel free to chat with them and tell them Ben sent you. What we do right now is there's multiple different product options that we have, whether it's the lumber material, the solar upgrade, a whole number of things. So basically what we ask you to do is, if you're interested, skip over to our website. We take down a bit of your information and we create a custom quote for you based on your location, where you are, and the cost of materials at this time. We all know that COVID has been hectic in terms of disruptions in the supply chain. We are no stranger to that. So we price on an ongoing basis. We can skip across to the next one. Yeah, basically just your standard kind of pitch deck. So not all of these slides are are perfect for talking more about the product. But as I kind of mentioned, the growing domes that we sell come in kit form. So we ship them in 3 crates, everything labeled, color coded, and ready for construction. So when it arrives, it's as simple as logging into your custom password protected portal, where you can see all of the different instructions for how to click yours together. Now, for the 15, it usually takes about 2 days from beginning to end to finish the whole product. For the larger 42-foot dome, it can be about 5 to 7 days, weather depending. I'm actually on an install right now, so I'm doing this from a hotel room just outside of where we're putting one up in Quebec City. We're doing a 33, and we're estimating it's going to take about 4 days to get everything up, done, and weather sealed. So very quick structures to assemble and get ready to use. And the next few slides are a little bit about us, so we can click ahead. Yeah, what's up?
Before we go to the next slide, I can't believe this thing can handle 180 km/h winds.
It's pretty remarkable. Basically, the way that it's able to do that is, if you're looking at the dome, all of the panels are on acute angles, and what that means is that any external force that is put upon it, whether from the side or whether from the top, results in a downward pressure. Similar to a race car foil, the way that it works is, instead of it being able to catch the wind, it results in a downward pressure. And that's really how we're able to get such remarkable numbers.
That's amazing. You know, my house was hit by a tornado, and I mean, tornadoes have higher wind speeds than 180, but still, I mean, that's, I mean, that it can stand up to those kind of wind speeds. Something else for the folks on the call today and those who will watch it later is polycarbonate is an amazing material. When I saw that in Ben's pitch deck, I really like that material. I built you know, skylights out of it that you could jump up and down on it, and they don't break.
No, it's remarkably strong stuff. And so we, I mean, just on the polycarbonate quickly, when we are sheathing these buildings, we are standing directly on top of it, and it's a material that's so light that you can pick it up over your head with easily with one hand, and be able to stand on top of it once it's installed. So right now, our marketing strategy is kind of fourfold. We appeal to the average Canadian grower, being, you know, right down to the smallest model, being able to put it up on a half-acre lot in your backyard, in an urban setting, being able to, you know, really take control of your ability to be able to grow the basics. If you want to keep it as a greenhouse, lots of folks will end up making it into, you know, it takes a little bit extra work based on what the kit currently is, but they'll make it into an office space. They'll make it into a Zen or meditation garden. They're able to change it into, you know, basically anything that they want, you know, that space to be. Yep.
How about a yoga studio for my wife and I?
Yeah, bingo. And we have a number of clients that have done exactly that. And one of the cool things that they do is they'll keep some of the greenhouse components, right? So instead of doing the whole floor space as growing, they'll do, you know, medicinal herbs around the outsides. They'll do beautiful flowers. They'll do wind chimes in front of the fans. And it's just your oasis in the middle of the city or in the middle of your day. And so we also work pretty closely with a lot of folks who are interested in doing cannabis production. We fall into a category with our largest structure, which allows one to become a micro grower or a micro cannabis license, which is quite interesting. So there's a lot of commercial potential there. The third is that we're kind of exploring the idea of being able to do similarly designed prefab housing in kind of this geodesic form. So that's kind of a research and development that we're playing with right now. And last but not least, we work pretty closely with a lot of nurseries, farms, landscaping companies, all sorts of these folks, because at the end of the day, if someone's wanting to really landscape their their property or add value or add appeal that just stands out from anywhere else. These structures are eye-catching, they're wonderful, and really, really lend credence to the ability to say, look, this is something I've never seen before.
Ben, I'm just going to stop sharing just for a second to ask another
question,
if I may. And if anybody, I don't want to hog all the questions. If anybody else has there's a couple of questions here. One from Topanga. Can you put do you need heavy equipment for larger installations?
You don't need it. So typically speaking, when we do the larger dome, so the 33-foot dome we're doing right now is a 850 square foot build. We're putting it up using ladders and scaffolding. Because everything's drilled out and it can be built modularly, you're never really lifting more than 50 pounds at a time. It's a strut or a board or a panel on the way up. And so no, it's helpful to have, but it's not necessary.
Another one here from Michael. This one I like especially. You had me at hello. I'm buying at least one, probably 5. That's I like that.
That's great to hear, Michael. Would love to chat. Please feel free to touch base. The easiest way is just on our website. We're more than happy to help you.
Then listen, don't do it if you're not comfortable doing it, but would you mind putting your email address in the chat box so people can reach out to you?
Yeah, absolutely. No, of course, that'll be the easiest way.
Well, just everybody, I think today, even my kids are using email. Ben at ArcticeAcres.ca. And there's another question from Cyrus. Great idea. Do you have plans and designs for the inside in order to grow food in the most efficient way?
Yeah, we do actually. So we have bed designs and bed plans for your traditional agriculture, meaning your raised soil growing. We have the plans done up until the 33. We're still working on plans for the 42. They should be done soon. That being said, not everybody wants to grow in raised beds. So I have a lot of experience in vertical hydroponic systems with lights and automation and that whole kind of ball field, so to speak. We also have a lot of growers that set up to do, mushroom inoculation, and that's a completely different growing setup required. So there's tons of ways that you can set them up. Short answer is yes, we have ways for raised beds, but you can really go crazy with how else you want to set them up.
One more question from Rick, if you don't mind.
Yep.
How does the dome function in drier and hotter weather? I mean, obviously we know it works in the Arctic, and boy, if you can grow veggies in the Arctic, you can grow them anywhere. But how does it function in hotter and drier weather like Arizona or Texas?
Yeah, so actually that's a great question. We have the American partner company who has been working in those exact climates. And they've actually come up with a number of different ways to be able to beat the heat. So instead of using a 1/2-inch thick polycarbonate, they go with a thinner polycarbonate, which allows more heat loss during the day. They have a built-in misting system, which allows sprayers to keep the humidity up and keep things from burning off. And then included standard, if you look in the videos that we see, that was shown earlier, you'll see what's called an aluminum shade cloth. Now, this shade cloth is made of an aluminum fabric. What it does is it reflects heat out of the greenhouse before it has a chance to actually warm up the environment. Yeah. So those shade sails, tongue twister, are included in the kit, and what they allow, basically you hang them up with a pulley system in the south wall, which deflects a lot of the immediate sunlight. And the other thing you might have noticed in the video is that included standard in all the kits is a geothermal pool, or a passive solar pool rather, in the north wall. That acts as a heating and cooling mechanism. In the summer or high heat conditions, that water runs cooler than the air. And then we run a small, pretty basic geothermal system around the inside perimeter of the greenhouse, pulling cool air off of that pond and putting it into your beds actually. And it works vice versa in the wintertime up here.
So just so everybody knows, that's also known as a geo exchange system, where you have a heat sink, which is, as Ben mentioned, both you can draw heat from it in the winter and you can draw cool from it in the summer. So it's also known as geo-exchange. Okay, my turn for a question.
Yeah.
Did I hear you correctly when you said that this you're looking at maybe turning these into small homes as well?
We get a lot of folks that are interested in being able to live in them. And so it's one of the things that we've kind of put on our back burner to say, you know, perhaps there's a larger opportunity here to compete in possibly a prefab housing market. So it's definitely something that we're keen to basically crunch the numbers on. So we've been hectic, crazy busy over this summer. So it's kind of my fall.
I think project. It's awesome, but I'm not sure if you can do it, but I've always wanted to, you know, I love greenhouses. So when I go into a greenhouse, I want to have an office there. I want to, you know, put my cot in there and sleep there. I mean,
yeah,
you know, so I see this as, you got a dome, you can grow stuff, you know, you can be on Mars, I suppose, you can grow stuff, you can sleep there, you can live there, work there, play there, do yoga there. So I do think there's tremendous potential. And your cousin is asking, can you install them with green roofs on a multi-floor building, i.e. apartment, office, or restaurant?
It can. We have had a lot of I should say a lot. We've probably had half a dozen people asking whether or not these can be installed on rooftops. Basically, you know, there's simple things that need to be, simple boxes that need to be checked first. Is the building rated for something on its roof? Is it in an area where, you know, bylaws allow for that? If all of the preliminary kind of check boxes come back, absolutely we can figure out a way to mount it on top of a roof.
If you think about it, Chris, it's rated for up to 180 kilometer-hour winds, so the wind thing isn't going to be the issue. I just really love the idea. All right, we'll go back to your slides now. I'll share my screen. I'm going to change this a little bit. Share screen 1. Get rid of this, and here's the next slide.
Sure. Yeah. So just kind of plugging our way through. There's a couple of other folks that they're primarily U.S. based. Although there is one in Canada. They're quite a small operation, mostly setting up to do kind of event spaces or some of those domes that you see out front of restaurants that people can eat in, or those really thin kind of glamping domes that you see kind of in the cheap social media videos. They only use a 4 millimeter polycarbonate, so it's quite thin. We're using a 16 millimeter, and the other are American based options that I mean, I don't know about my fellow Canadians, but it's a tough pill to swallow when I have to convert to USD and pay import taxes for something that's made here in Canada. So anyway, those are a couple of them. Next slide, please. So right now we are a 3-person operation. It's myself, Jordan, and TJ, who are brothers actually. And we've all kind of split up. So it's a lean, mean greenhouse making machine right now. But yeah, so we're a young company, and the idea is that, you know, we want to basically build a new style of manufacturing. Lean, quick, greenhouses out the door, small teams. So the next slide kind of backs that up a little bit. So we kind of launched into this literally when the pandemic hit. When I say when the pandemic hit, I mean Q1 2020. That's when we went to market. And it was a really make or break moment. So first year, just under $1 million in sales. This year, 2021, I think we'll close out somewhere around 3.5.
Wow.
And it's been fantastic. We've gone from, you know, 3 of us in the beginning. We now have a team of 5 full-time employees, with the monthly burn at, you know, 52,000. We own the property we manufacture on. We own the shop we manufacture in, and we own all of our equipment. So when you do business with us, you know that we're responsible for every step of the way. And so we take pride in our greenhouses. We take pride in being able to deliver them to hundreds of Canadians across the country. This year, we'll do 100 new greenhouses and 100 new building sites, 100 new permits. And so, yeah, we're really proud of all that. Yeah. And this is just a few more kind of quick milestones, as you can see, it kind of backs up the some of the sales information in Q1 for the first public sales. We built our own brand new facility, which is, as I mentioned, located just outside of Ottawa. We have about 55,000 square feet of shipping receiving. We have about 5,500 square feet of manufacturing under roof, which, as mentioned, is owned. So even in a pandemic, even in uncertain economic times, you know, we've proven that time and time again, sustainability is important. And, you know, we Canadians believe in our product. So we're thrilled. You can find us online. You can find us on Facebook, social media, everything else. We try to let our clients speak for us more than anything. So please feel free to check out some of the reviews and what people are saying online. So thank you all very much for letting me chat. If you have any other questions, I'd love to answer them.
Well, what an incredible presentation, and you know, 219% growth rate per annum.
We really exploded.
Wow, that's fantastic. So I'd just like to comment on something, Ben. One of the things that the pandemic has done is it has changed Canada and many other countries and their economies, I think, forever.
I agree.
And Canada absolutely has to be more independent. Our international trade partners, whether we're talking China or the United States, have proven to be unreliable. The Americans would not share their vaccine surplus with their neighbors. Had it been the other way around, had Canada and Mexico had a surplus and we refused to share the surplus, which wasn't even being used in our countries with the United States, I'm not sure what would have happened, but I would rather not know. So what it has proven, whether it's supposedly our American cousins or our Chinese folks across the Pacific, is that we have to be more independent in everything, in energy, in medicines. The fact that we're the only G7 nation that can't produce a vaccine, are you friggin' kidding me? We have a lot of smart people in Canada.
Absolutely right.
And we can't produce our own vaccine. I think that's ridiculous. So we can't produce our own medicines. We don't produce our own food. We obviously are an energy supplier, but maybe the wrong kind of energy. So what Ben is doing is he's caught a wave. And the pandemic has been terrible. It's killed millions of people. It's infected many more. So it's bad. But we have to learn this lesson, because if we don't learn this lesson, there will come a time when it will be a disaster of unparalleled proportions. So I would strongly encourage everyone to think about having something in their backyard. My wife and I, we have a backyard homestead, and I can tell you that the quality of tomatoes and herbs and spices and apples and other things we grow is a heck of a lot better than something that's been on a truck for days and in a supermarket for perhaps a week or two. So I would encourage everybody to get more familiar with this. One other thing I wanted to mention to you, Ben, you might not know this, but my wife and I a few years ago visited with Bon Jovi. He's an artist, a musician, composer in New Jersey, where he has a restaurant that you can go and get a nice meal there. But if you don't have any money, you can go there and get a nice meal and then put the work in.
Oh, amazing.
Yeah, it's amazing. So they grow vegetables and herbs and other things right on site. And of course, they have a farm not too far away. And so if you you had fallen on hard times and you need a meal, you can show up, get a nice meal, and then you have to put in a few hours of work in the farm, either right behind the restaurant. So where your cousin, where Chris was going, is another market. I mean, if I had a restaurant today, I'd want one of these domes where I could seat people, and I'd want another one where I could grow my own herbs, right?
Yeah, absolutely.
There are restaurant chains in Europe that do the same thing. They actually grow, like they have grow walls in the restaurants, and you pick whatever herbs you want, you put them on your salad or your steak or whatever, your chicken. So I would strongly advise that, I mean, I don't need to advise you on this, you know already, you're in a great industry that's only going to get much better. I'd like to be around in another 20 years to see where Arctic Acres is at, because I expect big things from you. I'm not sure I'll be here. I'm going to be 70 this year, so that might be a little long. But I really think it's fantastic. Are there any other questions before we let Ben go and we end it today? Barbara says she's awesome, love the concept. Anybody else have a last question for Ben? A bless you from this from Barb again. So that was a nice blessing. We all need that. We got a clap from Cyrus. So I'm going to do the same thing here. Ben, I'll put this thing on YouTube unlisted. You'll get a copy of it. If you want to use any part of it for your own promotion or whatever, you're welcome to do it. Chris, thank you so much for suggesting this. Ben, great job. Thanks, everybody. We'll see you later.
Thanks, everyone.